Civil Judge Junior Division and Law Examination, Law of Evidence, Admissions and Confessions in English language is the topic for discussion today. This topic was uploaded in Telugu language yesterday. Dear friends, you are aware the 152-year-old the Indian Evidence Act 1872 has been repealed and replaced by the new enactment titled the Bharatiya Saksha Adhiniyam, which came into 2023, which came into force from 1st July 2024. Even though the Bharatiya Saksha Adhiniyam has replaced this previous Indian Evidence Act, there are no drastic changes in the new enactment. The Indian Evidence Act, which is 150-year-old, contains such provisions which are repeated in the new enactment with change of sections only. Some sections in Indian Evidence Act are clubbed in new enactment. Some sections, new sections have been reproduced in the new enactment as clauses or provisions. The Indian Evidence Act contained 167 sections and 18 additional sections like 22A, 53A, 153A, 111A, 113A, 114A, like that. 167 sections plus 18 sections were there in the Indian Evidence Act. But this new enactment, the Bharatiya Saksha Adhiniyam, contains 170 sections along with schedule containing two formats relating to digital application to be furnished and submitted by the applicant in respect of information relating to a digital system, and one more format is prescribed, is given under the schedule to be signed by the expert of the digital instrument, digital operators. So, in fact, the number of sections increased by 3 in new enactment. Practically 15 sections have been reduced. In old enactment, Indian Evidence Act 1872, there were 167 sections plus 18 additional sections. Total comes to 185 sections. In the new enactment, Bharatiya Saksha Adhiniyam, the number of sections are 170. So, this is the position. From so far as the topics I have covered so far with reference to Indian Evidence Act and Bharatiya Saksha Adhiniyam, there is not even a single change in old enactment and new enactment except slight changes. In the Section 1 of Indian Evidence Act contains the title, extent, jurisdiction. Bharatiya Saksha Adhiniyam also contains a title, extent, jurisdiction. In Indian Evidence Act, Section 2 is a repealing section. So, according to Section 2 of Indian Evidence Act, all legislations or statutes dealing with principles of evidence were abolished. That is what Section 2 of Indian Evidence Act dealt with. But this Section 2, the repealing section is placed under Section 170 of the Bharatiya Saksha Adhiniyam. So, In Indian Evidence Act, Section 1, Title Extent Jurisdiction, Section 2 Repealing Act, Section 3 Interpretation Clause, various definition document court and all various definitions are there. In every enactment, Section 2 or Section 3, in some enactment, Section 2 contains interpretation clause providing so many definitions of that particular subject. In some enactments, Section 3 contains the interpretation clause dealing with so many definitions. So like this, what happened here, Indian Evidence Act, Section 1 Title, Section 2 Repealing Act, Section 3 Interpretation Clause, Section 4 presumptions, may presume, shall presume, conclusive proof. But these 4 sections in Indian Evidence Act are reformed as 2 sections are brought into in Bharatiya Sakshya Adhiniyam, only 2 sections. Section 1 as it is, Section 2 sent to Section 170, Section 3 and 4 are clubbed. So accordingly, by the up to 4 sections are reproduced as 2 sections here. From Section 5 to end of the section, 2 numbers are reduced. For example, Section 5 general rule, that general rule Section 5 in Indian Evidence Act speaks about general rule of irrelevancy. Section 5 to 55 deal with various exceptions. But here that Section 5 Indian Evidence Act reappears as Section 3, Section 3 res gestae reappears as Section 4 and so on and so on. So up to whatever topics I have discussed, only 2 numbers reduced, but all contents are in Indian Evidence Act and Bharatiya Sakshya Adhiniyam are same. Whatever changes are there in future, I will let you know in detail, dear friends. I sincerely tell you, don't think that the Indian Evidence Act has been vanished. It is no more a law. Though the act, the title of the act is will be no more, but the contents or the conscience, the most significant conscience or contents of Indian Evidence Act have been, most of them have been reappeared in this Bharatiya Sakshya Adhiniyam. However, it is inevitable and incompatible to bring about such changes. Instead of, if the subject is not recodified, the enactment is not recodified, we have to, we resort to Amendment Act. When once the subject is recodified, all the amendment additional sections will be removed. So in Indian Evidence Act, we will find additional sections like 22A, 53A, 11A, 111A, 112A, 113A, like that. But in new enactment, we won't find any additional sections of A, B, C, like that. So this is, dear friend, now I want to take up admissions and confession, the most important topic. I left some 3-4 section 10 to 14. I did not cover sections 10 to 14. Suits for determination of damages in respect of filing suit, state of mind, bodily feeling, accident, whether a particular accident is accident or incidental, course of business, custom. These small principles I did not cover. I will cover in course of time, dear friend. But up to this, only section numbers are changed, but there are no any substantial changes. Now let us now go to admissions and confessions. In when a civil suit is filed in judicial civil proceeding, when a criminal complaint is lodged in criminal proceeding, whether it is a civil case or criminal case, the judicial proceedings will take place from the time of filing the plaint and judgment in civil cases, from the time of filing FIR in police station or lodging complaint in a magistrate. The so many proceedings will be there in take place in criminal proceeding, inquiry, investigation, inquiry, trial, filing filing of charge sheet, numbering, so many stages, so many processes are there. So here, when generally why the litigation takes place is the person, the wrongdoer in civil litigation and accused in criminal proceedings do not admit the guilt. In order to ascertain the guilt, the court resorts to so many processes which involves lot of time and lengthy procedure, and thereby it will take months together, years together to arrive at the conclusion and to find out the realities of the case to deliver the judgment. Because the debtor who received money, who borrowed money from creditor, denies the debt, so he will not say truth. So similarly, the accused who committed crime will never admit, never admit in the court. That is why the procedures will be lengthened. If the debtor in the very beginning agrees that I have received money, I have borrowed, then the matter ends. That the statement of the debtor is called admission. Similarly, when an accused is brought before the court, in the very beginning, if the accused makes statement before the magistrate or session judge that I have committed that particular crime voluntarily, so then there ends the matter. The judgment can be given very quickly. The cases can be quickly. So in the absence of admissions, in criminal case or civil case, that means where the wrongdoer in civil litigation and accused in criminal proceedings do not admit the guilt on their part and try to escape from the liability, lengthy procedure takes place. If the admission is given in civil proceeding, the case can be completed very quickly. If the admission is given by the accused in criminal case can be cleared case can be decided very quickly. So this admission in civil proceedings is called admission. The admission in criminal proceedings is called confession. So this whether it is admission in civil litigation or confession in criminal proceedings, both are one and the same, because the defendant in civil litigation, accused in criminal proceeding, acknowledges the liability by making statement against himself. So that is why whether in civil proceedings or criminal proceedings, number of statements are given by the variety of parties to the case make statements, and authorized agents of the parties make statements, some strangers make statements. So those statements given by various parties in a witness box, they are called self-regarding statements. Whatever statements are given orally, the statement given in orally or in writing or in printed letters or written things or digital form, electronic apparatus, tape recorder or cell phone recording, CC cameras, so many digital formats, that is also documentary evidence. So whatever statements are there, these statements, oral, written, documentary or in digital form, given by the parties themselves, their agents or their persons called by the parties, or some other strangers who make the statement at their risk, liability and reputation, these statements produced before the court are called self-regarding statement. If the statement is if the person who makes the statement speaks in his favor, that statement is called self-serving statement. If the person who makes the statement before the court make statement against himself so as to cause harm or injury to himself, that statement is called self-harming statement. So in simple word, statements in judicial proceedings, whether civil proceedings or criminal proceedings, are called self-regarding statements. If the statement, a person who makes a statement to protect himself in his favor, that is called self-serving statement. For example, I am a very good man, I have done lot of help, I never do any wrong, I always do everything, always do good only. These are the self-serving statements. Nobody will believe, court will not entertain. Suppose I say, I am a very bad man, I have done lot of irregularities, I received money, I took a loan from bank, I did not repay, I took loan from a creditor friend, I did not repay, I committed a particular crime, I spoiled the life of somebody. Such statements, I say, they are called self-harming statements. They are believable and admissible in the court of law. So these self-harming statements are called admissions. These admissions in civil litigation, civil proceedings are called admissions. These proceedings, these self-harming statements in criminal proceedings are called confessions or confessional statements. But this chapter, section 15 to 25 of the Bharatiya Saksha Adhiniyam, section 15 to 25 of the Bharatiya Saksha Adhiniyam lay down the provisions relating to admissions in civil proceedings. And sections 17 to Section 17 to 31 and 21A, these provisions in all admissions from both civil and criminal proceeding according to under Bharatiya Saksha Adhiniyam, section 25 to section 15 to 25, total 11 sections lay down the provisions relating to admissions under Bharatiya Saksha Adhiniyam. The corresponding sections in Indian Evidence Act are section 17 to 31 and 22A, totally 16 sections. Those 16 sections dealing with admissions in civil and criminal proceeding are reduced. 5 sections are reduced. Old Act 16 sections, New Act 11 sections are there. So out of these, some sections 15 to 21, sections 15 to 21 and 25, 7 plus 1, 8 sections of Bharatiya Saksha Adhiniyam, section 15 to 21 and 25 of Bharatiya Saksha Adhiniyam, 7 plus 1, 8 sections lay down the provisions relating to admissions, that is admissions in the civil proceedings. Section 17 to 23, section 17 to 23, 22A and 31, these 9 sections Indian Evidence Act deal with admissions in civil proceedings, and 22 to 24 Bharatiya Saksha Adhiniyam, only 3 sections deal with criminal proceedings, confessional statement. This is the sections wise clarification about present Bharatiya Saksha Adhiniyam and this thing. So here only 3 sections deal with confessions in new enactment. In old enactment, 9 sections dealt with 9 sections dealt with this criminal confessions in Indian Evidence Act. So I don't like to confuse you further. So now let us now discuss about what is admission, what is confession. Admission or confessions, both are same, because in admission the defendant will admit the liability. In criminal proceeding, the accused will admit the liability. So making self-serving statement in civil case is admission. Self-harming statement in the civil case is admission. Self-harming statement in criminal case is confession. Admission in civil cases, confession in criminal cases will speed up the trial. So in the admissions in civil proceeding, confessions in criminal proceeding play most important role. In the absence of the admission or confession, there will be lot of procedure, there will be long delay in arriving at the trial, to complete the trial and to pronounce the judgment. Now let us now discuss about what is admission. Admission is a voluntary acknowledgement. Admission, Section 17 Indian Evidence Act, Section 15 India Bharatiya Saksha Adhiniyam. So Section 15 Bharatiya Saksha Adhiniyam or old Section 17 of Indian Evidence Act defines the term admission. This admission means admission is a statement. Admission is a statement, oral or written or documentary or contained in electronic form, which suggests any reference as to any fact in issue or relevant fact, which is made by any of the persons under sections 16 to 18 under Bharatiya Saksha Adhiniyam or section 18 to 20 under Indian Evidence Act. So 16 to 18 or 18 to 20, just two number is different. This present Bharatiya Saksha Adhiniyam 16 to 18 is equal to Indian Evidence Act 18 to 20. So these sections deal with the persons who are qualified to make admission, or who are qualified to make qualified to make admission in civil litigation. So admission is a statement. Admission is a statement. It may be oral by words of mouth. It may be written, letters or something. In document, printed documents are there, or any other documentary evidence in digital form and computer storage, CC camera, WhatsApp messages, cell phone messages, whatsoever may be, they are also have been included in the definition of document in the recent past, but when it came into force, the new Bharatiya Saksha Adhiniyam has come into force. So that is so here this oral or written or documentary or electronic form statement is one that makes inference. That makes inference as to fact in issue or relevant fact. The person, by making that self-harming statement, clears the doubt, clears the dilemma as to the fact in issue, whether a particular debtor received money or not, whether a particular the defendant who is claiming property is real owner or not, whether whether in mortgage the mortgagee who is claiming redemption of the property, the subject matter is genuine and all formalities complied with or not. All these things can be cleared by making admission. If admission is made, it is final. No further evidence can be resorted to. So that is why this evidence has, what is the effect of evidence? What is the effect of this admission? When once admission is given, so the court process will become very easy. The case can be completed very quickly. So when the accused admits that I have committed that murder, no further proceedings can be taken up. When the debtor agrees that I have received the money, no further proceedings can be taken up. So the process can be very easy. So here, what are the various forms? In what ways the admissions can be made? The person who wants to make admission by making who wants to make admission in what are the various forms? Number one, the admission must be the admission may be oral or written or documentary or in electronic form. That is first condition. The admission in civil proceeding may be oral or written or documentary or in electronic form. That is first thing. So, the admission should be made voluntarily. The person who wants to make admission in court must do it voluntarily. He should not be subjected to any undue influence, inducement, coercion, force, promise, favor, anything. He should suo moto, voluntarily, wholeheartedly should make admission. Sometimes the admission need not be oral or written or documentary all times. So admission in form of a soliloquy also, that is which refers to conduct of the person, the attitude of the person, the bodily feeling of the person. From that feelings also the admission can be inferred. Suppose the person who received money is questioned in the court in witness box. When he is questioned whether you have received money towards loan from so and so money, then he is not able to speak something. His feelings may be different, his conduct will be different, facing on the symptoms of the body, attitude, bodily feeling, everything. That is what is called soliloquy. Basing on that, a person's even though the admission is not given in form of oral statement or documentary statement or electronic form, the admissions can be inferred from the conduct of that person. That is, so another thing is admissions can be given by signs or gestures. Suppose the person who appears in witness box to make admission. Suppose the person who wants to make admission is deaf or dumb or due to ill health he is not able to speak. He can give admission statement. He can give admission by gestures, by nodding his head, and all these things. So gestures, signs, conduct, soliloquy, and all these processes, the admissions can be made. Sometimes admission can be given to oneself. So admission need not be addressed to anybody. Even suppose when the debtor tells, I have received so anyway I should win the case. I should not repay even 1 rupee to that man. We took money at time of need. There is no need to give him back all the money with lot of interest like that. He himself may think in his home and somebody may be had. That also amounts to admission. So this will be applicable in criminal cases also. There are admissions are various forms in oral, written, documentary, electronic form, and soliloquy, gestures, by gestures, by silence, by signs. All these processes will be there for admission. Now, what are the conditions? What are the conditions to be fulfilled for admissibility of the admission? So, number one, the admission, a person who wants to make admission, the admission must refer to self-harming statement only. He should make statement against himself. It should not be a self-serving statement. So, self-serving statement. So, the statement should be given under the circumstances section 16 to 18 of the Bharatiya Saksha Adhiniyam, the corresponding sections, section 18 to 20 of the Indian Evidence Act. Section 16 Bharatiya Adhiniyam, 18 Evidence Act, 17 Bharatiya Adhiniyam, 19 Evidence Act, 18 Bharatiya Adhiniyam, 20 Evidence Act. So both section corresponding sections. So 16 Bharatiya Adhiniyam speaks about persons, agents, other parties to suit, authorized agents are qualified. Representative persons in representative capacity, persons having pecuniary interest, all these things. So section 19 and 20 deal with strangers other than parties. These points I will discuss. So the person who wants to make admission must give the statement against himself. It must be a self-harming statement. It must be made under the circumstances of section 18 to 20 of the Bharatiya Sakshya Adhiniyam, formerly section 18 to 20 of the Indian Evidence Act. The admission must be with reference to relate to the subject matter in issue. Subject matter in issue in debt, loan is borrowing money is subject matter. When a title of the property is questioned, seller between two parties, A claims that a particular property belongs to himself, A, but B challenge that it doesn't belong to A, it belongs to B. So that property is called the subject matter. That property is called subject matter. If house is insured, house is subject matter. If a human being is insured, human being is the subject matter. The statement must be with reference to the subject matter of the contract, and that the statement should be relevant. Relevant means connected to this. You are qualified means your degree is relevant. You are rich means your property is relevant. So that statement, admission given by the person must be relevant. He must give voluntarily. It must be very precise, as small as possible. He should not tell cock and bull stories. Cock and bull stories. It must be fair, clear. He must speak very clearly. He must maintain clarity. He should not speak in such a way nobody is able to understand. So it must be very clear. It must be audible, and it should be understandable. It should not be vague. It should not be ambiguous. It should not be ambiguous. Similarly, lastly, the admission must be in full only, because the admission, the statement of admission would not split into pieces or parts. So the statement should be as a whole. However, in certain circumstances, if the admissional statement is lengthy one, a part of it is, some parts of it is relevant, some parts of it are not relevant, the court can entertain such part which is relevant to the case, and the court can reject some other part which is not relevant to that case, and follow it. It depends upon the discretionary power of the court. This is with reference to so, and once the admissions given by the parties or authorized agents, it will be a very good evidence. And further, when once the admission is given by the party to suit or authorized agents, it cannot be further challenged. It can be treated as conclusive proof. However, there are certain circumstances admissions are not conclusive proof. It may be in the event of estoppel, and all these 4 points I explained in detail, and we are going to discuss them in detail. So now, so in Satish Kumar versus State of Uttar Pradesh, the Allahabad High Court said that an admission or pleading, pleading or judicial proceeding by itself can be made the foundation for the right of the parties. When so the admission is such a strong, it is treated as foundation for the right of the foundation like a foundation with reference to right of the opposite party. If one party makes admission, it will be a good foundation, good strong, we gives a lot of strength to that. So next one is admission by silence. Admission statement made by silence. Whether the admission by silence is admissible or not. Yes, admission by silence is also admissible. There is a relevant case, Basela versus Stern, 1877 case. In this case, what happened was there is a boy and girl, lovers. The girl said, you always promise to marry me, but you don't know, you don't keep your promise. So there are two lovers in this case, and the girl tells, you always tell that you will marry me, but you don't keep up your word. That is her words. But then the boy keeps quiet, he keeps quiet. He did not give any reply for her words, and at the same time he did not challenge her words. So in this particular case, the silence by boy amounts to admission. So amounts to admission, and it is accepted as admission, and the interest of the girl was protected. Similarly, silence in another case. A woman went to silence constitutes illegitimacy in certain cases. A woman went to school seeking admission of her child, but when the boy's father's name is asked, the woman is unable to tell the boy's name. So she was maintaining silence. Her silence not to reveal the name of the father amounts to illegitimacy, and the child, the woman doesn't know who is the father, and then the child who is seeking admission to school is illegitimate child. So silence also constitutes admission. This is what. So the admission must be whole, not in part. So the statement of admission should be taken into consideration as a whole, because it cannot be split into parts. But however, when the court wants to entertain particular part as relevant and admission, and does not consider some other parts not relevant, it can reject. But subject to discretion, the relevant part can be accepted as admission, irrelevant part may be rejected by the court. But in normally speaking, admission must be as a whole only. You should not be in small in parts. The relevant case on this point is Shivram versus Shivcharan, 1964, Rajasthan High Court. Next, computation. The person who are competent to give admission. Section 16 Bharatiya Saksha Adhiniyam, its corresponding section 18 Indian Evidence Act speaks about who are the persons competent to give admission. Number one, parties to the suit. Debtor can say, yes, I have to pay money to that creditor, or creditor can say, yes, that debtor need not pay money to me. That is a statement of creditor. He need not pay. Creditor say he need not pay. That is admission. Debtor say, yes, I have to pay. That is admission. The property, the person, the possessor of the property, who doesn't have right title with defective title, says that he doesn't have right title. He is having only defective title. Opposite party is the real owner. If the one party defendant tells, then it is called admission. There can be no further argument. So if party to the suit makes admission, then it is if the parties to civil litigation, that is plaintiff and defendant, or petitioner or respondent, appellant or respondent, these are the parties who can make admission. Sometimes not only the parties under section 16 Bharatiya Adhiniyam 18 Indian Evidence Act, first one is parties, secondly their authorized agents or authorized representatives. The party by power of attorney, the person party to the suit may depute somebody to to represent his case. When that authorized agent makes statement, it is he is qualified. But the parties advocate also, defendants counsel or plaintiffs counsel also can make admission, it is right. Sometimes the statement made by family member or wife or husband are subject to fulfillment of certain condition, that is also will be eligible. Another category is persons in representative capacity who can sue and who can be sued. Suppose the managing director of company can sue others, and others can sue. When others want to sue, he can sue the managing director only. So that managing director of company is called person in representative capacity. Whatever admission he makes, it is acceptable. Suppose the vice chancellor of university or controller of examination of university makes an admission that in particular examination mass copying took place, they are going to they took decision, they passed resolution to cancel that particular exam, degrees awarded are disqualified. So that statement is admission. The controller or vice chancellor of the university under representative capacity to sue and to be sued, that that person also is qualified to make evidence. Another category under section 16 Bharatiya Sakshya Adhiniyam, 18 under Indian Evidence Act. One more category is person who is the person by making this admission, he suffers any loss, he loses any pecuniary interest, that man also is qualified. In partnership firm, all partners, if partner makes any admission causing loss to the firm, he is also suffering some loss. Suppose there are 5 partners, one partner makes a statement by that 50 lakhs is lost, this partner also will lose 10 lakhs. Suppose in admission made by co-owner about the defects of this. Suppose the owner, 2 persons are owners of the house. If it is given for rent, that rent is shared by both. Suppose any statement is made by one co-owner causing some loss, the statement by both the person who loses loss by making statement also is qualified like a partner. That is another thing. Suppose you gave your motorcycle to mechanic for repair. Mechanic, you tell him to sell it for 20,000, but the mechanic says that it is not 20,000 worth, it is only 15,000 worth. Suppose the mechanic will get 10% interest. If it is sold for 20,000, he will get 2,000. If it is sold for 15,000, he will get 1,500. If the mechanic tells that it is worth 15,000 or 15,000 or 10,000, that statement made by that mechanic also is made out of pecuniary loss. So he is also qualified. So the next one is, last one is person. The persons who the person from whom he derived pecuniary interest also is qualified to make admission. Suppose buyer and seller is there. Today, seller is having the possession of the property. It is transferred to buyer after sale. So, whatever statement is made by, statement admission made by seller is admissible, or buyer with reference to property is admissible, because the person from whom he derived interest, that is buyer. The mortgagee, the person from whom he derived interest, mortgagor. So the statement made by mortgagee or seller buyer also will be taken into consideration as admission. These are the four categories who are qualified to make admission. Like successor predecessor. Successor predecessor means principal retired and new principal appointed, and the new principal derived interest from the old principal. The statement with reference to his office and everything, statement made by predecessor, that is can be an admission and admissible. This is with reference to under section 16 Bharatiya Saksha Adhiniyam, who are the persons qualified to make admission is given, and this section is studied under section 18 of the Indian Evidence Act. So under section 16 Bharatiya Saksha Adhiniyam, the parties and authorized agents and otherwise agent directly related to the case are qualified to make admission, but other than the strangers also can, the general rule is stranger to contract cannot sue. Similarly, the stranger to case, stranger to litigation cannot make admission, but however section 17 and 18 in Bharatiya Saksha Adhiniyam, corresponding sections 19 and 20 under Indian Evidence Act are exceptions to section 6. Other than the parties, some outsiders, strangers also can make admissions. What are the other strangers? So here the persons, any other than the parties or authorized agent, any person who wants to make admission at the cost of liability, at the cost of loss, at the loss of his reputation, is ready to make statement, then that stranger's statement is admissible. That statement is admissible. Suppose I am not a party to the party, when the dispute is there between A and B, as a C and I go and I make, by giving in order to justify either A or B, I make a statement. By making such statement, I suffer some loss, I get some liability, I lose my reputation, or otherwise, if having prepared to suffer something, if I make a statement in the interest of either of the party to the litigation, that statement also can be accepted. That is what section 17 in Bharatiya Saksha Adhiniyam or section 19 in Indian Evidence Act speaks about. So here, for example, A appointed B to collect interest. That is illustration given in the Bayer Act and books. A is the principal. He has so many properties. B is his agent. B has undertaken to collect rents for A. So one of the tenants is C. So B went to C. A asked B to go and collect rent from C. But after some time, B said, C need not pay rent to us. C owes no duty to pay rent. B said like that. But the B, who has to act on behalf of A, said that C need not pay. But C himself, no, I should pay rent to A. I owe duty to pay rent to A. This, by making that statement, see, here A and B are parties to suit. C is a stranger. Though he is not party to the suit, C has come forward to make a statement at the cost of some loss. So when once he makes that statement, he is bound to pay rent to the A, though B denied his authorized agent. That is another one stranger, the stranger who is prepared to lose his position, the stranger who wants to make this admission against his interest, against loss, against his reputation, etc. That is also can be that person also is qualified to make admission. Next, Third category, Section 18, Bharatiya Saksha Adhiniyam, Section 20, Indian Evidence Act. Who the other category, who is qualified, other stranger. 16 parties to suit, authorized agents. 19 and 20, other than the parties to suit, the stranger to party cannot give admission, but section 17 and 18 under Bharatiya Saksha Adhiniyam, section 19 and 20 under Indian Evidence Act are exceptions. Other than the parties to suit also are qualified to make the admission. Accordingly, if the party of this side or that side refer some other person to give evidence, make statement, that statement is admissible. Here some illustration is given in the Bear Act and textbooks. This illustration is: A sold his horse to B. B asked A whether the horse is sound, or whether it kicks, or whether it has any defects. Then A said, go and ask C. That C is the person who is taking care of that horse in taking here and there and giving training and all. C. Then A said, go and ask C. Then C said, no, this horse is not good, it is sound. Because that person, because A referred C's name, since A referred C's name, whatever C said, it is admissible. That its admission is admissible. With this, the persons qualified are this thing. Some 21 onwards, section 21 Indian Evidence Act, 19 Bharatiya Saksha Adhiniyam speaks about exceptions. Self-serving statements are not admissible. Self-harming statements are admissible, because here some self-serving statement also are admissible. The relevant things are dying declaration, persons who cannot be called, and res gestae. This dying declaration, they are also exception to the hearsay evidence, and they are also exception to the general rule of section 5 Indian Evidence Act, general rule of section 3 this. So this is with reference to what is called admissions. This topic is mainly over. Other sections are there, they are negligible. Here section 23 Indian Evidence Act 21, it speaks about admissions in civil cases when relevant. So when there is an express condition that the party tells that this particular initial matter should not be revealed. For example, in life policy, in application form, the family details are furnished by the insured person, applicant, and under the condition that their particulars should not be mentioned. All these things are there. And now the time is not there. Let us go for confessions. Section 24 to 30, 7 sections in Indian Evidence Act. Section 20 to 24, only 3 sections in Bharatiya Saksha Adhiniyam speak about confessions. So admission is a self-harming statement which strengthens the position of opposite party. So by that, it forms basis or foundation to the case, and case can be decided quickly. So these self-harming statement in criminal proceedings are called confessions. So here, according to old Act, admission, 7 sections are there. These 7 sections are adjusted in 3 sections in the Bharatiya Saksha Adhiniyam. These 4 sections, 2 were treated as provisos and 2 were treated as clauses in the section. According to whatever section 24 Indian Evidence Act said, section 22 Bharatiya Saksha Adhiniyam tells. So the confession is most important thing. The confessions are the best proof. The confessions are very important for formation of the case, when once a confessional statement is made, the case can be decided. The significance of confession is there. So when a person, the accused, who wants to make confession, he must make the confession voluntarily. He should not subject to, his statement must be trustworthy. He should not subject to any inducement, threat, undue influence, etc. And whatever rules for admission, identically same rules are to be complied in this thing. So here, confessions are the best proof. The importance of importance of confession is enshrined in two Latin maxims: confessio facta in judice omni probenton major est. This means confession in judicial proceedings is greater than any other proof. And another is the confessio facto in judicio est plena probatorio. This confession is the absolute proof. So confession is better than any other proof, greater than any other proof, first one. Second one is confession is the absolute proof. Proof is second. So the confession is the best means of evidence. Best means when once the accused makes confessional statement or confession in the court, then the case comes to an end, then case can be finalized, provided the confession, when the accused makes a confessional statement, the magistrate should tell them, if you agree now, you will be convicted, and you should be enlightened, he should be educated the consequences of making confessional statement, and then allow him to make the confessional statement. Still, the accused gets prepared to make confessional statement, that will be recorded, and accordingly the person will be convicted. So confession is most important aspect in criminal proceedings and criminal proceeding. Section 22 to 24 of Section 22 to 24 of Bharatiya Saksha Adhiniyam lay down the provisions relating to confession. Section 22 Bharatiya Saksha Adhiniyam or Section 24 Indian Evidence Act deal with confession by inducement, threat, favor or promise is irrelevant. Suppose if the court, when the accused is there before court hall, if the session judge or magistrate tell, you agree to this, you admit this offense, I will reduce your punishment. That is called promise. So inducement, in some movies we see, you have to agree that you have committed this accident, otherwise I will kill your family members. If you agree, a lot of money will be given to your family member. If you go agree for this, that is called inducement. So if any undue influence, coercion, if you don't agree for this offense, I will kill you, I will break your head, I will kill your wife, or kill your child, like that. So if the person, accused person before your court or magistrate is influenced by coercion, undue influence, inducement, etc., such confessional statement is irrelevant. It cannot be accepted. Whatever is said in Section 24 Indian Evidence Act, the same thing said in Bharatiya Saksha Adhiniyam. And Section 23 statement, Section 23 Bharatiya Saksha Adhiniyam, all situations of statements to police are under Section 23 only. But whatever information, whatever provisions are given in Section 23 of the Bharatiya Saksha Adhiniyam, they are given in different section 25, 26, 27. Whatever statements with reference to police are given in Section 25, 26, 27, all the three provisions are enlisted under section 23. So according to 26, confessional statement made to police officer, that is section 24. So section 25, 26, confessional statement to police officer in police custody in the presence of magistrate. Section 27, confessional statement made to police officer. First part of the statement refers to commission of the crime. Second part of the statement gives clue for investigation, that is admissible. So this section 27 is shown as provision and other two are shown as clauses to section 23. So section 25, 26 and 27, these three sections are adjusted in section 23 of the Bharatiya Saksha Adhiniyam. According to section 25, 26, 27 or section 23 Bharatiya Saksha Adhiniyam, the position is the confessional statement made to police officer is not admissible because police officers are not trustworthy. They may influence by beating or inducement or anything, motivate the accused person to make confessional statement. That is one reason. So that is why confessional statement made to police is not admissible. Secondly, if confessional statement made to police officer in police custody also not admissible according to section 26. Suppose in that time, if confessional statement is made to police officer in the presence of magistrate or sessions judge, then that confession is valid and admissible. So confessional statement made to police officer in the presence of magistrate is equal to confessional statement made in court only. And court, what if confessional statement is made in court or confessional statement is made in police station, police office, before police officer in the presence of magistrate, that is also relevant and admissible. Section 27 is there. Section 27 Indian Evidence Act is there. It is given as a provision in Bharatiya Saksha Adhiniyam section 23. What happens here is the accused in police custody tells, I killed somebody. I killed Mr. So and so. If you tell me where I hid, where I buried him. Second statement, I killed Mr. X, not admissible. But in police station, A said, I killed B. That is not admissible. If I will show you where I buried his body, then that is so. Okay, show me where you buried the body. This man is taken and taken to the spot where the body is buried. Then the second part is valid, admissible. So confessional statement in police custody contain two parts. First part relating to commission of the offence. Second part gives a clue for investigation of the case, to speed up the case, that is admissible. However, such a statement which also includes clue must be voluntary. It must not be given under compulsion. There is a relevant case on this point is Pulukuri Kotaya versus Emperor. Pulukuri Kotaya's case is the Privy Council judgment. In this what happened that the Pulukuri Kotaya and others were charged for murder of Sivaya, Subbaya and two persons. And the Kotaya in police custody said, I along with some other waited for the deceased and others, but we could kill him. Subbaya and Kotaya, Sivaya and others, Sivaya and Subbaya who died and others escaped. We killed them with some some deadly weapon. If you take me out, I will show you where I hid that particular spear. Basing on the investigating part, the case was, he was taken to this spot to find out the spear, and the section 27 contains the confessional statement made by accused in police station comprises of two parts. First part relating to commission of the offence, latter part relating to clue that facilitates the investigation of the case to complete the process. Now, there is an argument whether Section 27 of Indian Evidence Act or the proviso 3 of the Section 23 of Bharatiya Saksha Adhiniyam, whether they are unconstitutional, because Article 20 Clause 3 of Indian Constitution tells that no person should be compelled to give evidence against himself. No person should be forced or compelled to give against himself. So, according to Section 27 Indian Evidence Act or proviso of Section 23 of Bharatiya Saksha Adhiniyam, the person in police custody gave statement relating to containing clue relating to the investigation. Because of that statement only, that statement is nothing but the statement against himself. Article 20 Clause 3 tells that no person should be forced or compelled to give evidence against him. Here, this man is given where it is unconstitutionally challenged. But the Supreme Court said that the Supreme Court cleared this doubt that this is the state of Bombay versus Katikallu Ojad, 1961 Supreme Court said that no, if the person accused in police custody suo moto voluntarily makes such statement giving clue for investigation, it is not unconstitutional. If the person accused in police custody was forced or compelled to give such statement, it may be unconstitutional. These are the position with respect. Section 30 of Indian Evidence Act and 25 of this Bharatiya Saksha Adhiniyam speaks about confessional statement given in respect of joint criminals, accomplices, joint conspirators who include abettor also. When a crime is committed by two or more persons are there, two persons are there, two or three persons may be conspirators, one of them may be abettor also. Suppose one person is caught and asked to give evidence, the person who caught by police, who is one of the conspirators, who is one of the accomplice witness, who is one of the conspirator, makes a confessional statement, I along with so and so committed that particular crime, gives. So that statement affects the other person or all other who are involved in that crime. That is with reference to joint crime. This is with reference to confession. Dear friend, now I have completed confession and admission. Confession and admissions are very important topic in most of the exams here will be there. That is why Section 15 to 25 of Bharatiya Saksha Adhiniyam lay down various provisions relating to admissions, and see here only three sections, 22, 23 and 24 deal with confessions, remaining sections admission, but the title is only admission. But confession, all are admissions, self-harming statement, but special form of admission is confession. Confession relates only to criminal cases only. That is why every confession is an admission, but every admission is not confession. Like every agreement, every contract was an agreement, every agreement is not a contract. If agreement is enforceable, that agreement becomes contract. If agreement not enforceable, it remains as agreement. So that is why confessions are included in admissions, admissions are not included in confession. That is why every confession, all confessions are admission, but all admissions are not confessions. This is the topic. Question may be given. Dear friend, I sincerely suggest you to follow my lectures as and when notified, so that when once you only student career only, you will be able to learn the subject. When once you join some senior advocate as a junior, join, you start your profession and join with some senior advocate, you won't find any time. That is why I am suggesting my student friends, after immediately after completing LLB, if in case you did not did not concentrate on subject, you are not well equipped with legal knowledge, I suggest you sacrifice one more year. After taking your degree, 3-year LLB, you take and you enroll in some high court, and in the same place city you join some competitive exam center for judicial service exam and other competitive exam, because there will be lot of competition. While seeing the other candidates, you will get lot of inspiration to work hard day and night, and will be able to learn. The competitive exam people also, teachers also, by virtue of their experience, place before you so many model question papers and will train you how to this thing. Their training and their coaching will be, you will be able to digest, provided you have knowledge. Yeah, you have knowledge in law. Without having any knowledge, even if you join any competitive center, you won't be able to follow them. However, even if you work hard that 1 year, day and night, learning subject and receiving tips from the competitive exam center people, you will be able to get very good knowledge. You will have a lot of inspiration. If you are lucky, you can get selected as judge and go to court directly as a judge. Or otherwise, even otherwise, you can go to court with good knowledge. If you don't have enough knowledge, you don't deserve to be a learned counsel. Judge calls you learned counsel in court of law. When you don't have any knowledge, when judge calls you learned counsel, you feel guilty to be called as learned counsel. So this is what I suggest you. You follow my lecture. Sometime recently I gave long gap because of my throat trouble and other personal problem. Similarly, vacation time students don't concentrate in studies. So wish you all success. God bless you. I am putting this title Judicial Service Junior Exam because I am giving very elaborately lectures. The number of lectures have been increased. The volume of the time, duration of time is increased, standard is increased, reference is increased. So that is why these lectures are not only useful to LLB students studying prosecuting legal studies in prestigious institutions of legal studies, and also the candidates appearing for competitive exams and judicial service exams also. That is why the caption is Civil Judge Junior Division and Law Examination. It is useful. These lectures are useful not only for LLB, LLM and judicial services exam. Please utilize my classes so that I can have inspiration to upload more and more lectures. Thank you very much. Thanks a lot.